Hello and welcome back to Coursecast. Today I'm joined by two Oxford lawyers, and we're going on a bit of a deep dive about what law at Oxford is really like and what makes it unique. So if that sounds interesting to you, stick around, like, comment, share, subscribe, and here's some highlights from today's episode.
Rest of the hour,
We
but
literally spent a 2-hour flight from Malta to the UK talking about constitutional law, and this was a flight from like
it was quite
11 at
quite a
night
late
to like
night
2
flight.
in the morning.
Wow.
Coming to a place like Oxford, or even a place like Cambridge, UCL, LSE, coming to these top law universities,
Edinburgh.
Edinburgh as well, of course.
As a Scottish person,
Yes.
Hey, Cardiff University's not too bad as well. I'm gonna show support for the Welsh as well.
I think
So you can't actually read it anymore.
that's
They're
actually one of the things when we study Roman law. You'll get to the institute, you'll be reading the Institutes of Gaius, and he says, the things that make this are, and then it goes next 6 lines illegible. And then it jumps.
So it's
Okay, brilliant. Could you guys just introduce yourselves so we know a bit about who we are talking to today? Edwin or Umberto, either one. Let's go Edwin first.
Okay, I'm Edwin, and I'm a second year at St Emmet Hall in University of Oxford studying law, or jurisprudence as we call it here.
Cool.
Yeah, my name is Umberto. I'm also a second year law student studying law with Italian law, which means I have a 4-year degree instead of a 3-year degree. I get a year abroad in Italy. And I'm studying law or jurisprudence at University College.
Right. So the reason I brought you here today, guys, is to kind of give us a feel of what Oxford law specifically is like. And I think we've agreed the best way to do that is to just talk through some cases and give people a feel of what kind of the tutorial style of learning is going to be like if they end up at Oxford. So over to you. Talk me through some of the most interesting cases that you've studied so far here. And yeah, just take it away. I don't mind who goes first.
So I think one of the cases that we find interesting is the criminal case R v Brown from 1994. So Umberto, if you want to sort of take us
Wow.
as politically correctly as possible through the facts.
You've given me a great honor, Edwin, to be able to explain the facts of Brown. This is so. If you're studying criminal law, this is probably a case that you're going to come up against. It's to do with consent and whether or not the degree of harm that you can legally consent to receive. So, in short, and it will be short, the facts of Brown are you've got a group of essentially homosexual people, and they've all collected together for some sexual activities, which we will not describe, but they are very sort of they're a bit violent. They have particular fetishes, and
They've got
sort of,
elements of sadomasochism.
yeah, elements of
essentially.
sadomasochism, and they do things that would be considered grievous bodily harm to each other for the purposes of their own sexual enjoyment. The police then, for unrelated reasons, stumble across video recordings of all of these sort of acts that were happening between the defendants in this case. And obviously, because they were recording all of these things to then distribute amongst themselves for their own enjoyment. Afterwards, the police find these recordings and press criminal charges. The question, obviously, in the case being, are they committing a crime? Because obviously they've all consented. So there wasn't any question that they were there. They all wanted to be there, at least. Well, there actually is a question, but that's a bit more into the details of the case. The sort of surface level of it is that they all wanted to be there. They all agreed to everything that happened to them. The question is, have they committed a crime nonetheless? Can you consent to have grievous bodily harm inflicted upon yourself? And the courts actually found that the answer to that question is no. You can't consent to grievous bodily harm or actual bodily harm to be taken onto yourself, unless it falls into a series of exception categories. And Brown outlines those exception categories. There are, I think, about 7.
Yeah, so
that are
they're
outlined.
quite a weird selection of things. They
Yes,
definitely
they are.
reflect. I would argue they reflect the biases that elderly men had 30 years ago. For instance, these judges had all been in the army during the Second World War, so they make an exception that you can be violent for rough horseplay
Yeah,
and things like that. And then also religious flagellation, which
yeah.
is a very weird exception because I don't think there'd ever been a case where
I actually don't think
that had
so
been in
either. I
question.
don't think
So
it's actually come up.
it's you can see sort of here the
Yeah.
personal biases of the judges. You can there's one of the comments that one of the judges makes in that case in his judgment, which is it's thankful that some of these men are now in a normal heterosexual relationship. So I think that things like that can be revealing of the sort of biases that we saw at play in that case.
Definitely. I think it's important to sort of, I mean, Brown very much puts to the forefront the fact that at the end of the day, it is judges who are making these decisions and they follow the law. But because we have a common law system, not a civil law system, there's a lot of flexibility with what the judges can actually do with the law and the way that they want to do it. And sometimes, as you said, it can reflect their personal biases. And I think Brown is sort of a creature of this. A lot of people actually don't disagree with the decision in Brown, the fact that you can't consent to GBH being inflicted upon yourself, because it's got some sort of public policy things. You don't want people running around the street stabbing themselves in broad daylight and then be able to say that, well, that's fine
Yeah.
because you can consent to doing it, right? So there's clear sort of policy reasons and public policy discussions. So some people might say that Brown was rightly decided. It was the right choice. This is a good thing. Society shouldn't encourage people being able to commit self-harm or consent to harm being committed upon them. However, obviously, as you said, in the judgment, it's very clear that these judges maybe did not have these other considerations at the forefront of their minds. Maybe some of them did, but some of them clearly had some more dubious reasons for why they decided to make that decision. And especially, I think, contrasting the case of Brown with another similar case, I believe it's the case of R.V. Wilson, where essentially the facts of this case are slightly, we can discuss them a bit more than the facts of Brown. It's a man and a woman, they're husband and wife, and they basically, the wife wants to be branded by the husband. So she says, all right, take this knife, take this hot knife, and I want you to brand your initials into my, um, into a part of my body. And essentially, she goes to the GP then for unrelated reasons. Afterwards, the GP sees this branding
Yeah,
that's
right.
been done and calls the police. And the police obviously press charges and everything goes there. And it's a similar thing. It's grievous bodily harm. Um, and the question is, well, could she consent to it? And the judges in that case very tellingly say that this is the matrimonial home and it is not
Mm.
the purpose of the law to intrude in the privacy of the matrimonial home. Completely different type of rationalization and justification to something like R.V. Brown, where in that case, you know, when it's a bunch of homosexual people engaging in sadomasochism, suddenly it is the law that should intrude into the privacy of that home. But something very similar, like branding between husband and wife, suddenly it's the matrimonial home. It's not for the law to
I
intrude.
think it's very interesting. One of the differences between R.V. Brown is that none of the men in R.V. Brown actually seek medical treatment. One of the justifications in R.V. Brown is about public policy and the strain on the health services, but none of the men,
Mm.
all the injuries of these men have sort of
Yeah.
healed and they've gone away themselves.
Yeah.
The argument in R.V. Wilson is that it falls under one of the exceptions we were discussing in Brown,
Or
and that
horseplay, or
well, I think
Very
it's
rough horseplay.
body
Tattoos
tattooing.
and yeah,
okay,
But then you see cases like the
BM.
Dr. Evil case, which was a more recent case,
okay,
and this man ran a business. And I mean, he wasn't like he was doing this in his basement. He was on a street with.
He was a tattoo
He
artist
was a
basically.
tattoo
So he was a
artist.
cosmetic surgeon. Well, not like a qualified surgeon, but
right,
essentially he was running surgeries on people for body modification. But things like, for example, tongue splitting, removing things like ears, you know, really sort of weird stuff. But
yeah,
you know, a lot obviously he had a market. You know, people were into this, and he was running them from this sort of tattoo shop.
Yeah,
It's the case of RVBM, which I think was from 2018.
yeah.
I
It's
wanna
it's
say. It's
not
a
a
very
very
recent case.
old case.
I mean, Brown itself is from the 90s. I think it's
94.
94. Yeah, you're right. Um, Wilson, I think, is a bit later than Brown. It happens after Brown. But yeah, so it shows, as sort of Edwin was saying, that, you know, they tried to justify Wilson on the fact that this is actually more like a tattoo. So they were saying that the branding with the knife is actually a tattoo.
mm.
Which, I mean, like, whether or not you're convinced by that, you'd have to look into the case in a bit more detail, maybe yourself. It's not the most far-fetched rationalization, but I think that then when you look at cases like R and BM, where it's sort of like, you know, there's also a guy who's similarly doing tattoos, body modifications, this kind of stuff. It just seems like the law is a bit not incoherent, but that the individual biases of particular judges and the time in which those decisions are made also
I think something about the
impacts the judgments.
incoherence in the Dr. Evil RBM case is that the tattoo artist in that case probably was unaware that what he was doing was illegal.
Yeah.
It's likely that he would have said, if somebody had asked him, is this legal? And he had the background of the law up until that point, he'd have said, well, it is grievous bodily harm, it is actual bodily harm, but it falls under this R.V. Brown exemption of tattooing and body modification
Mm.
in that case. And the court says no. And I think it does raise issues
Yeah.
of sort of
Certainty.
certainty, knowing what you're allowed to do, which is supposed to be one of the sort of key
Yeah.
things holding our constitution together.
And we'll come to discuss that as well when we look at positivism and the rule of law. The importance of knowing what the law is and knowing, being certain that you're operating within the bounds of the law, because a law that's not followed because it's not known can't really, if you take certain views, be said to be a law at all.
Okay.
So it definitely has wider and broader implications. But yeah, I think Brown's a very interesting case, particularly because it's a product of the context of its time. I mean, it was, as I said, in '94, so this was like at the peak as well of, we were just coming down from the AIDS epidemic and HIV and sort of, diseases arising from sexual intimacy. And of course, a lot of people attributed those diseases to homosexuality. And it's very likely the judges had that in their mind as well when they were making that decision. So it just goes to show that, like, judges have a lot of flexibility and, for better or for worse, sometimes make decisions based on the policy at the time. And we'll come to cases where actually the policy reasoning that the judges are employing is for better rather than for worse. I think Tenancy and Bruton is probably a good example of that, and we'll come to touch on that in a bit. But certainly in the case of R.V. Brown, it's far more questionable whether
Yeah.
the judges had the best interest of society or the individuals in the case.
It's really interesting because obviously we're seeing, firstly, that somebody can make a right judgment without having the right reasons,
Mm.
but also with the whole common civil law distinction. How, like, my understanding of it is that it's almost like a growing organism, or something more organic than something in like civil law. So it's cool for me to understand how like our law's evolving, I guess. And I suppose I'm interested to ask you both in terms of like your evaluation of that. Like, do you think that's a good thing to have a legal system that can be almost well, it can change so much and also be with the power of the judges? Do you think it would be better if we had a more sort of concrete set of more inflexible laws, or is it good that we've got this sort of flexibility?
Well, I know Umberto probably takes a different view on this from what
Okay,
I do,
cool.
but I would say I feel that the law isn't rigid enough.
Right.
I think that there's probably areas like you've seen with R.V. Brown where we, as citizens who are sort of have to follow the law, we should know what the law is.
Mm,
And I think there's issues with having judges make, well, maybe not make in some people's view, but interpret the law quite often, not being able to remain impartial. I think having a more rigid set of rights, more rigid constitution, more rigid separation of powers, knowing where the boundaries are, people can't overstep, would probably be a positive thing.
okay.
But I know Umberto, you probably
Yeah,
take a
what's the counter
completely opposite
argument?
view on this.
I'm a big fan of flexibility. I
Right.
think that the flexibility of the law is one of the greatest strengths of our common law system. You often see in other civil law jurisdictions, for example, in Italy, France, Germany, countries that have a civil code, the judges in those cases, they'll open up the book and they'll read the provisions in the code, and they will maybe be able to interpret the provisions in different ways. There is still a degree of interpretation, but there's no, for example, like creatures of the common law, like, for example, the offense of murder actually being a common law offense
Right.
that arrived as a result of the common law. It's not really statutory. You would struggle to find the definition of murder in a statute, but something like that would never happen in the civil law, which means that concepts and ideas can grow over time to match society.
Mm,
So this is like, I think the most common debate with this type of idea is always the debate of written versus unwritten constitution, or codified versus uncodified constitution. And the UK obviously being a very rare example of a country that actually has an uncodified constitution. So we can't point to any one individual document and say, this is our constitution, these are our rules, our rights.
mm,
We instead point to a series of documents. We point to statutes, we point to the common law, we point to conventions, we point to politics. And from everything that we point to, we then build our constitution and we glean our rights from that. Sort of in broads, I mean, obviously, this is a massive debate area, and I think Edwin and I again disagree a bit because I actually quite like our unwritten constitution or uncodified constitution. I think it has a whole amount of benefits, in particular, flexibility being one of them. But it's a give and take, you know, with flexibility, you lose certainty. But just because certainty, you know, certainty is not the end all be all. I mean, if every time that, say, someone committed a theft, the fine was £5, that would be a very certain
Yeah,
law,
for sure.
but it certainly wouldn't be a very good
Yeah,
one,
yeah, yeah.
right? So certainty, whilst it's something to strive towards, in my view, isn't the top priority. The top priority should always be justice and fairness and reaching the right solution in the case. And for that reason, I think that flexibility is very important, and our common law and uncodified constitution help preserve flexibility.
And I guess then you can always rely on the law to reflect the kind of customary morality of the time rather than it being like, because obviously you can update like laws even if you've got a constitution, but um, that's going to probably take longer than if you're letting judges have a bit more freedom. I don't know, maybe I'm
I
wrong
guess
there.
I would push back on the idea that the morality of the time is a good way of basing the law. For instance, in R.V. Brown,
Right.
it's
Yeah.
certain that the morality of the time is playing a part there. I mean, you look at a poll in the mid-90s,
Yeah, for
how many
sure.
people believed that homosexual relationships were a positive or negative thing? You'd probably say the judges probably sided with what the majority of the country thought. But it's not the job of the judges. Well, it shouldn't be. And I think this is one of the problems with our unwritten constitution and having this sort of judge-made law is that it is a reflection of the time. I feel the law should always be protecting unpopular minorities, and I think
Okay.
an unwritten constitution could sometimes fail to do that.
Right. Cool.
I think that's very interesting because I kind of I agree in large part, but I also think that flexibility of an unwritten constitution can actually allow sometimes for changes in societal views to be more quickly incorporated into the law. For example, I think that if you have a fixed constitution, a written codified document, or a written law, the difficulty in changing that, because obviously when
Yeah, yeah,
something's
yeah.
fixed and codified, you view it as valuable. So it's hard to change. Otherwise, it loses the point of being fixed and codified. So going through the difficulty of changing that, at the time, if we were to have a codified constitution, it probably would reflect society at the time because law generally tends to some extent, reflect society. And so it's possible that we might have had a written constitution that actually prejudiced
Yeah,
homosexual
exactly.
people.
Yeah.
And then changing that might have been much more difficult than if we had a flexible one, which has allowed it to sort of adapt and change over time. I think a good example of this, probably right now, a lot of people might agree, is the Second Amendment in the US, where it's you've got this archaic sort of old provision that certainly had its purpose and had its reason when it was made. Obviously, back a long
Hundreds of years
time
ago.
ago,
Yeah,
hundreds
yeah.
of years ago. But now that society's changed and firearms and the state of firearms have changed as well, people come to question whether or not that provision and that amendment still holds the same purpose that it held when it was made, and whether or not it actually needs to be modified. And people often use the fact that, oh, it's codified, it's in our constitution, as a way to push back against that, when in reality, if maybe it wasn't codified, if they had something like our constitution, it would be able to more accurately reflect changes in the times.
Cool.
So I think that's a good example, regardless of your opinion on the Second Amendment. I think it can be used as a good benchmark to explain the point.
Yeah. Right. So I get the impression that you guys could talk about this for a long time.
Yeah.
Can we move on to maybe some other, let's still in the realm of criminal law, move on to some other cases that you think people might find interesting? Or we'll give like 5 to 10 minutes for each, and then move on to maybe something that's not
Yeah.
just criminal
Move
law,
on to some civil stuff
civil
as well.
stuff. Yeah, perfect.
So I think one of the cases that I've also find interesting is R.V. Clinton. This is a sort of case about voluntary manslaughter.
Mm.
In law, I know Umberto, you could probably cite the exact statute and provision that this comes from. Um, we allow people to reduce their charge of murder to the crime of voluntary manslaughter, even though they intended to kill that person. And one of the ways we do this is what's called loss of control manslaughter. And we essentially, you imagine loss of control in the sort of classic way someone was so enraged by what somebody said. Obviously, the law has sort of modified so it's no longer that sort of traditional in its interpretation. But one of the interesting exceptions to loss of control in statute is that you cannot cite a loss of control defence due to being enraged about adultery. And R.V. Clinton sort of examines how that's done. So,
Yeah, so it's sort of, yeah, to reiterate what Edwin was saying, when you have the offense of murder, just generally broad stroke, it requires two parts: the intention and the action. So the conduct element and the mental element, the mens rea and
Is
the
that the
actus
same with
reus.
any kind of like
Yeah.
almost
Most
any
most
crime.
criminal offenses,
There's
strict
things like
liability.
there's things like drink driving. You
Yeah.
can, even if someone slips vodka into your soft drink, you're still liable for drink
Really?
driving
Wow.
because then everyone would say
Yeah, of
that.
Exactly.
course. Yeah, yeah, yeah. Yeah.
There's certain
Strict
things that
liability offenses.
you wouldn't be able to prove an intent. It would be so
Mm.
difficult to prove an intent that really what would happen is drink driving wouldn't be an
Yeah,
offence.
yeah, yeah.
But for the most part, yeah, you do need a mental intention or at least a recklessness. So
Okay,
like you knew something ran a risk of this happening and you did it anyway. But
got it.
and generally you also, for you, almost, I can't think of any time you don't need a positive act really, unless
Yeah,
apart from omissions cases, which we'll talk
maybe
about later.
touch on.
Yeah.
Yeah. No, that's very true. So yeah, for most criminal offenses, you'll need a conduct element and a mental element, and for
Right.
murder, that's no different. So very briefly, for murder, you need to have the intention. First of all, you need to actually kill the person. There needs to
Mm.
be factual legal causation, and also you need to have the intent to have either killed that person or, interestingly, the intention to commit grievous bodily harm. Now, that's an entirely separate debate on whether or not that's actually good, because it
Yeah.
makes murder a constructive offense, which means it's much more broad. You can intend to stab someone, intending only to stab them and not kill
Mm.
them, but
Yeah,
if
yeah,
they
yeah.
wind up dying, you're still guilty as if you intended to kill them. Um,
I think it probably just goes back to what we were saying earlier, though. Nobody would ever, if the defense to murder
yeah,
was
I
you could
mean,
just
there's
Yeah.
stab
yeah,
somebody and
it's
say, well, I didn't
Yeah.
think that would
Yeah.
kill them, then that's what
I
everyone would be
just
doing.
wanted to stab them. I
Yeah.
didn't mean to kill them. Yeah. So essentially, the way that loss of control works as a voluntary manslaughter offense is that you basically say that you intended to kill them, so you had the intention, you did kill them, so you have both mens rea and actus reus, both conduct and mental elements
Right.
have been fulfilled. So at the minute, you're guilty, but you say there's a third factor, and this is usually in the form of um, an excuse. So you basically say, look, I intended to kill them, I did kill them, but it's because they either did something that caused me to fear serious violence from them,
Mm.
or it was something that they've said or done which has caused me a justifiable sense of being seriously wronged. So this is the example in Clinton falls into this second category. Now this is a statutory defense, so it falls under the Criminal Justice and Immigration Act. I think it's in the 50s. I think it's like 54, 56.
Okay.
Um, and essentially, what they outline, it outlines these two qualifying triggers, but there's a very particular subsection that says that sexual infidelity or adultery can't act as one of the qualifying triggers for things said or done. So if you, for example, walked in on your partner being unfaithful to you, and you're so overcome with rage, you have this visceral reaction, and you look to your right and you see a plant pot, and you just
Yeah.
hit the
Yeah.
the
Yeah.
person who they're with, or the partner, their head over with it, and it kills them. You intended to kill them. You wanted, you did it,
Yeah.
but you can't use loss of control as a defense to that. You
And
can't use
why
it as
do
an
you think that
excuse.
that's kind of emerged as an exception? Like,
I think probably one of the main reasons is something we were talking about before we came on here, which is that adultery isn't a crime.
Mm,
Although, like, it's probably terrible if you're in that
yeah, yeah, yeah,
situation. We don't put people in prison for it, so it's hard to argue that you could be doing something legal,
mm.
but it's also in the same breath justified to murder you.
yeah, yeah,
Like, I think it would just be seen as a contradiction in the law, and also it's something. I think it's a sort of, from a feministic viewpoint, it's something that a sort of abusive husband
yeah,
would be
yeah,
likely to cite as one of those things. And one of the main things about the reform of loss of control manslaughter in the last sort of 20 years has been to make it so that
To protect
to
women
protect women in
mm,
and
abusive
swallow
right,
hell.
relationships.
Yeah,
okay,
definitely. It's actually the loss of control defense used to be called a provocation. So it was the common law defense of provocation before they made it statutory, I think, in
Right.
2008.
So you had like this kind of precedent that had developed through lots of cases, and then Parliament basically came along and said, "We don't like the precedent that's
Yeah.
emerged. Let's put in an actual statute and
Yeah.
We'll codify it.
Okay,
So
right.
sometimes when Parliament makes laws, they decide to codify existing common law. So they won't necessarily maybe change much. They'll just take the rules that the common law has developed and they'll put it into statute.
Okay.
Sometimes they will change things massively. With provocation and loss of control, obviously, as Edwin was saying, the main emphasis was to shift the protection. It was to protect basically women in abusive relationships and also to stop this idea of victim blaming as much. Because
Yeah.
obviously, just the name of the offense, loss of control, puts the emphasis on the defendant.
Mm.
Oh, you lost control. Provocation puts the emphasis on the victim. Oh,
Mm.
you
Yeah,
provoked me.
yeah.
So
Yeah.
it's very subtle things, but it shows the way that the
One
law
of the
of
things that
Parliament
was
wanted
happening
to
with
develop.
provocation was that what would happen is an abused wife who murdered her husband in his sleep
Mm.
wouldn't be able to claim provocation, but an abusive husband who was annoyed
off the
by his
handle
wife
Yeah,
would
yeah,
actually be able to
would
claim
be
it.
able
So
to.
what loss control did is it took out this component of and the sort of instant rage.
Yeah.
It meant it so this
Yeah.
the woman abused woman who kills her husband in his sleep would only now be liable for would be able to claim this loss control defense if the rest of the components were met.
To a limited degree
Yeah.
as well. I mean, there's a very famous case of Ahluwalia. This is a wife who was suffering abuse for years from her husband, and at one point it was just the straw that broke the camel's back. She just cracked and essentially went in the middle of the night and poured gasoline all over her husband and set her husband on
Ah,
fire.
wow.
Some might say that was deserved. I'd probably fall into that category. That
Okay.
on the fact of the case, he was a terrible guy. But under provocation, she would definitely never have had a defense.
Mm.
In this case, she actually didn't get a defense under loss of control either, which is very interesting. But she was able to get a defense under diminished responsibility, which is
Okay.
another
I
defense
think
category.
sort of tying this back to R.V. Clinton,
Yes,
the
definitely.
result in this case is that essentially the courts arguably ignored this provision
They did.
that didn't allow loss of control for
Right.
infidelity.
Yeah.
It's you see this sometimes with the court sort of sidestepping provisions they
Yeah.
don't like, and this is definitely arguably a case of that.
Absolutely. I think it's incredible when you look at the facts of Clinton. It's really fascinating to read the judgments like in full. I'd recommend
Where could people find that?
So a lot of judgments can be found on Bailey. If
Okay.
you don't have access to a legal database, if you study a law degree, you will probably you will definitely be given access to a legal database, for example, like Westlaw. That's probably the only way to find judgments in full. Otherwise, there's a lot of online
The
sort of
Supreme
case
Court
summary
website
websites.
as well
Yeah.
generally has the judgments
Okay,
of
Supreme
okay.
Court
cases.
decisions, I think since 2009 now, are published on the Supreme Court website, including press summaries, which are actually designed to be read by both law students and the public.
Okay, cool.
They're not legally citable documents in of themselves, but they do provide like a paragraph breakdown. They're essentially like they'll condense like a 60-page judgment into like 2 pages. They're an absolute lifesaver. So it's like definitely the press summaries for the Supreme Court, Bailey, if you're just a non-law student, case summary websites like lawteacher.net, Ipsa Loquitur is very good. Elawresources.net's okay. Lawprof is also okay. And things then, for example, like if you're a law student, obviously Westlaw,
Yeah,
Leases,
cool.
Fine Online.
Should we
I
take
mean-
people out of the suspense of what the judgment in R.V. Clinton
Oh, yeah,
actually
what
said?
actually
Yes.
happened?
Yeah. Well, the judgment in Clinton, the judge actually goes on this like really long like spiel, like describing the facts of the case. Essentially, what they say in Clinton, the way they work around this rule, is they say that sexual infidelity can't be the trigger, but it can be considered in addition with other things.
Right.
So in Clinton itself, the facts of Clinton very briefly were this dude was in a relationship with his wife, they had kids, the relationship was breaking down, the wife was essentially being quite just behaving very poorly, saying things like, oh, I should have never been with you. I never wanted the kids. You should like, he basically told his wife that he wanted to, like, he was having suicidal thoughts. She found him looking at like ways to commit suicide on his laptop. And she basically said, oh, you don't have the guts. You would never do it.
Wow.
You should, but you will never will. And essentially he invited her over one day to the sort of family house, and he found out that she'd been like unfaithful with him, and he wanted to confront her about this. And in the sense of confronting her, she just basically flies off the rocker and just starts hurling all these insults at him, saying like, "Oh, you're a terrible husband. I should have never had the kids. You know, I'm going to take the kids away." All of this like really terrible stuff. And essentially, it just causes something to snap. He, I think, quite brutally beats her to death
Right.
with, I think, a belt and a bat or something like that. And then he tries to kill
Right.
himself in the attic with the belt. Not a very pleasant case, but the courts essentially, he actually doesn't succeed in killing himself. The police
Right.
are able to intervene in time, and they save him. Um, and then obviously he stands trial. The courts held that the sexual infidelity element, whilst it was there, he was confronting her as a result of the sexual infidelity, and he was certainly angry as a result of the
Mm.
sexual infidelity. There was so many other things going on in this case. There was the comments made about his depression. There were the comments made about the children. There was all this other stuff that sexual infidelity was actually a bit ancillary. And so even though sexual infidelity was there, the exception didn't come into play. They were still able to focus on the other things, and the sexual infidelity could just build on that background. So it kind of shows that while sexual infidelity can't be the only trigger, it can work in conjunction with other things. So this is another example, for example, where the law is able to be a bit more flexible
Yeah,
and
for
is able
sure.
to provide a defense to people in instances where maybe statute seems to forbid it.
Cool. Right. That's extremely interesting. Let's hear one more criminal law case, then we'll chat about some other ones.
Should we talk about Thin Skull?
Yes, that's actually really fun. Do you want the thin skull or eggshell skull rule? Do you want to explain the? Do you want to go for Blaue, since Blaue's criminal law, and then you can explain Leech brain and
Yeah.
Right. Great.
So essentially, the Thin Skull rule in a sentence would be that if you commit a crime against somebody, you take the risk that they have a particular weakness.
Right.
So to sort of put that into um, something a bit more tangible, RV Blau. So this is a case where um, a man attacks a woman who's a Jehovah's Witness, and it causes her to need to have a blood transfusion. She's taken to hospital, and they say, "We'll save you through this blood transfusion," and she refuses the blood transfusion on religious grounds.
Mm.
Now, there's no real doubt in this case that had she taken the blood transfusion, her injuries were survivable. And so the man is in court, and the question is whether he is guilty of murder
Mhm.
as a result of her decision.
Mm.
And the court, although they don't use the words eggshell
They
skull,
don't, they
as
don't use the
Umberto
words
was
egg,
pointing out to
shell,
me
or skull.
earlier, they employ what's called this eggshell skull rule. They'd say, well, when you attacked this person, you took the risk that they had a particular weakness
Yeah.
that would cause them to suffer this injury more greatly than they otherwise would have. And in Blau, they extend this to cases where there's a religious belief
Right.
or a mental reason, as
Yeah.
opposed to up until this point, the cases had all been for a physical illness,
Yes. Yeah.
like an allergy or some sort of
Or a
issue,
literal thin skull.
or a
Right.
As the
literal
name
thin skull.
implies,
Okay.
yeah,
Yes.
you
Yeah.
push
Yeah.
someone over and they hit their head on the pavement, they've got a thin skull.
Yeah.
The normal person wouldn't have died, but this person did.
Right.
You, are you liable
Yeah.
for
Yeah.
that
Yeah.
for that difference?
Yeah.
The courts say you are.
Yeah.
And as
And
Edwin said in Blau.
you see this as well in tort law as well.
So what's tort law?
Okay. Do you want to take that?
Well, the law of torts or torts, depending on what you believe. Essentially, it's the English law's civil wrong system. So, to very, very briefly and probably controversially define a tort, it is a civil wrong other than a breach of contract or an equitable wrong. So, for example, things like negligence, nuisance,
Okay.
Trespassing.
trespassing. Very interestingly, trespassing is not a criminal offense unless it's sanctioned by statute. So unless you see a statute that says that it's criminal for
Mm.
you to trespass, you can actually trespass, and you're only liable civilly. But obviously, there can still be big consequences. That's probably the biggest thing, to be honest, about tort law, is that the line between tort law and criminal law can sometimes be quite blurry,
Okay.
especially in cases of, for example, gross negligence manslaughter, where sometimes if negligence is gross enough, it can be criminal. In other cases, it may just be civil. So that's the important part.
And
It's
what? Sorry,
not
just to
criminal
interrupt. What's the
liability.
practical implications? Like, if I'm in charge under criminal law, what difference would that be to me being charged under civil law?
The civil law is a tort law, sorry, is a private institution.
Okay.
You're in criminal law, if you've punched Umberto, for instance, you are being taken to court by the state. You're not
Okay,
being
got
taken
it,
to
got
court
it.
by Umberto. Whereas in tort law, he's
It'd be me
suing you
Right.
for the tort of having
Been
Punched.
punched.
been
Yeah,
punched,
yeah, yeah. Cool,
essentially.
cool.
So in criminal law, it's the sanctions of the state, and in tort law, it's the other person.
The
Mm.
rights of
generally,
private individuals.
yeah.
Cool,
And
right,
the
sorry, yeah, carry
practical
on.
implication obviously being that if you get convicted in criminal law, you're probably going to go to prison.
Yeah.
If you're found liable in civil law, you'd probably just have to pay me money.
Mm.
One goes on your record. I don't think the
One
other
of the
would.
things about tort law is there's a much lower standard of proof. So
Okay.
you might be found not guilty of having punched Umberto in court because to be convicted in criminal law,
yeah.
you need a
Beyond reasonable
beyond
doubt.
reasonable doubt
Okay.
standard to be found guilty. Whereas in tort, you need to be found to have punched him on the balance of probabilities.
Right.
So essentially, in
It's like 50-50 instead of
Yeah,
99%.
yeah.
So I think that's one of the key differences. You could end up being not guilty of that in criminal law and liable in tort.
Which
So
is really, really interesting. You do get cases where people are technically innocent in criminal law, but then the courts actually find that, oh, well, it wasn't beyond reasonable doubt, but on the balance of probabilities, you probably
Yeah,
did
right,
this.
okay.
And so they're then liable in civil law, which is a really interesting area.
Mm,
But I
for
think maybe
sure.
to bring it back to Blaue,
Yeah.
one of the most controversial parts of Blaue is obviously the fact that it extends this rule, the thin skull rule, to not just the physical person, but the whole person, including any psychological quirks or
Yeah,
traits.
yeah.
So before it used to be that, as Edwin was saying, it's just if, say, you had like dormant, malignant, like non-malignant tumor that was made malignant by the act of the defendant, and
Yeah.
therefore you
I think
it,
the
like
Smith,
accelerates
Smith
it.
and Leech brain is too interesting to just gloss over.
Yeah,
Like
go on.
that.
Let's hear
I'll
it.
tell
Let's
you,
hear it.
you
Let's
can-
hear it.
this is a
Essentially,
good example
Smith
of the
and
physical elements, Smith and Leech
Brain.
brain.
Smith works for the company Leech Brain,
Okay.
and he deals with a lot of molten metal. And unrelated to this, unrelated to his work, he has a non-malignant tumor on his lip,
Right.
and molten metal splashes onto his lip, and it causes this tumor to become malignant, and it kills him.
Hmm.
And his estate sue Leech Brain, and the court ends up saying, well, you were negligent by not providing this man with the proper personal protections, and under the eggshell skull rule, you're also liable for his death
You have to take
Right.
your victim as
because
you
you've taken
find
him
them.
as he is.
Yeah, sure.
And as soon as they've committed this wrong negligence, they're now liable for his particular weaknesses.
Yeah. So Smith and Leech brain's a good example of it being the physical side of things. It's also an example of it being in a civil law. So the Smith and Leech brain weren't criminally liable. They didn't kill him. They
Hmm.
were just negligent in not providing him with the particular
Yeah,
protection, which
sure,
then
sure.
meant that his estate could sue Smith and Leech brain for money, uh, in compensation of their negligence. But in criminal law, so it serves to show the example of previously in criminal law it was just physical. Now it's psychological as well. So in the Jehovah's Witness case, the thin skull wasn't a literal thin skull.
Yeah.
It was a psychological thin skull. This person, the victim, was a Jehovah's Witness. It was
Yeah.
her choice. So obviously that's, you might on the one hand think, well, yeah, fair enough. Someone's choice to be a Jehovah's Witness and you need to take your victim as you find them. And if that means taking them as a Jehovah's Witness, that means taking them as a Jehovah's Witness. But the trouble is, when do you consider that particular characteristic to be part of the whole person? For
Yeah.
example, if she wasn't a Jehovah's Witness, but just realized, oh, you know what? I actually just really want to spite this guy. I'm just a vindictive person. You've stabbed me, and you know what? I want you to go to prison for the rest of your life, so I'm going to refuse all help, all medical care, so that I die and you get convicted of murder. Is that part of the whole
Yeah,
person?
yeah, that's super
Suddenly,
interesting.
that seems now like the vindicative person. We're a bit less empathetic to them than we are to the Jehovah's Witness.
Yeah.
So that's the crux of the debate, whether or not the thin skull rule, as a result of Blaue, which is a recent case, I think it's just 2014, whether or not it's pushed it too far, and whether or not we need more restrictions on taking the victim as you find them. Because otherwise, yeah, you could get someone who's just, having a bad day, decided that, I mean, the classic rebuttal to it is obviously, just don't go around stabbing people.
Yeah, of course.
I mean, hey, you gotta, argue in
I think
abstract.
there's definitely situations you can see. For instance, if two drunks outside a pub have a knife fight and one of them stabs the other one, but this person could have been saved, but then
They just
they're
decided not
so
to.
drunk
Yeah.
They don't recognise it. The paramedic comes to say, "Get away from me," sort of thing.
Yeah.
Right.
There's that sort of case where it's not like
It's
this
not
deeply
clear.
held religious
Mhm. Yeah, yeah,
belief
yeah,
the way
yeah.
it is in Blaue, but then we
Is
don't
that
have
is that a
proper
thin skull?
like case law to say whether this would be a
We've got to
thin
wait for
skull
that to
case.
happen before we actually
Yeah.
know
Yeah,
what
which is
judgment we're
another
making.
problem, I think, with this sort of judge-made law,
Yeah.
that there's not this certainty. There's so many of these areas where we're saying, well, we'll just have to wait and see.
So if I was
what
in a
judge
drunk
decides.
knife fight, I wouldn't know if I was gonna be done for murder or something less
yeah.
harsh.
Yeah,
Right.
essentially.
Okay. That's very, yeah.
So yeah,
Mm.
I guess the rationale is just don't get in a drunk knife
Yeah.
fight.
Yeah. Good advice. Thank
But
you.
I mean, it's a really interesting area of law, which is why
Yeah.
we had it.
I think it is worth noting, though, that if you come and study law at Oxford, it's only was it you said earlier, 1/9
Yeah.
Yeah, this
of
is really
the
important. Most
amount
people
of
think criminal law is like the law.
Yeah.
In reality, criminal law, at least at Oxford, is only 1 out of 9 modules that you're going to be studying, and it's one of your mods modules. So it's and when you come here, you'll have your moderations, which are your first 3 topics,
Okay.
which will be criminal law, constitutional law, and Roman law. And you get examined though in those at the end of the second term of your first year. Those don't actually count towards your final degree. And you will not study criminal law again unless you choose it as an optional module in your third year and you choose advanced criminal law. So it's like if you're interested in law, ask yourself whether you're interested in law or whether you're interested in criminal
Yeah,
law.
for
And if you're
sure.
just interested in criminal law, you're going to have a great first 2 terms, but after that
Yeah.
you might struggle to
Yeah.
find the passion still being there.
Yeah.
So it's an important
I
consideration.
think there's definitely other areas where you
So
can
many
study criminal
areas.
law, like criminology, things like that.
Yeah,
You don't need
sociology.
to. I think people who have an interest in this sort of criminal justice thing, you don't need to
Yeah.
come and do a law degree to be able to pursue a passion in that. But in the interest of that, we're going to talk about some
Yeah.
of the other areas of law that we find
Mm.
interesting.
Yeah, there's 2 things really. Firstly, I'd love you to talk about Roman law because obviously that's
Yeah.
quite a unique thing to Oxford. But also, I think it'd be good to give people who are watching a bit of an idea about what are you going to be learning outside of criminal law? Because as you've said, it's not actually. It's a very small minority of what you're actually going to be learning.
One of the other modules, as Umberto said, that we study in first year. This was the first ever module I did when I arrived at Oxford. Is constitutional law.
Okay.
So we could talk about this for the rest of the hour,
We
but
literally spent a 2-hour flight from Malta to the UK talking about constitutional law, and this was a flight from like
it was quite
11 at
quite a
night
late
to like
night
2
flight.
in the morning.
Wow.
I think everyone on that flight hated us
Yeah.
by the end of it.
So the thing we've sort of
We'll keep
bookmarked
it
that we're going
brief.
to talk about is prerogative powers. So the thing, to give you a definition of prerogative powers, they are things in law. They're things that the king can do that, well, by virtue of being the king. It
Okay.
sort of stems back to when the king was actually in
Yeah.
charge.
Yeah.
So these are things like they're a weird list of things now because essentially the way you get rid of prerogative powers is Parliament passes a law that says Parliament does this now.
Yeah.
So it's essentially things that Parliament have never done that for. So there are things like appointment of the Prime Minister.
Things like passport controls as well, like
Okay.
the
Yeah.
distribution of passports. Importantly, the ability to prorogue Parliament is probably one of the most important prerogative powers, and we're going to come to talk about the prorogation of Parliament if we'd end up discussing Miller 1 and Miller 2, specifically Miller 2, because well,
Yeah.
obviously
There's other things like
massive case.
declarations of war.
Right.
Things like that is something that technically the Parliament has no control over. I mean, conventionally in the 21st century, Parliament gets a vote on this sort of thing. But by law, if the king decided tomorrow he wanted to go to war with France, the king
They could use their
legally does have
prerogative
that
powers.
power.
Wow. Okay.
Importantly as well, the prerogative powers are now obviously they're residual. They're a residual of what was left from
Yeah.
the king's
Yeah. Yeah.
power, but it's now held by the executive. So it's held by the government, the prime minister in particular. So that's why most recent example again of prerogative powers that everyone will probably really know about and still remember. It's still quite fresh. Is Boris Johnson's prorogation of Parliament in Brexit. So this was, I believe, like in 2019, yeah, 2019, 2020, where Boris Johnson prorogued Parliament for 6 weeks.
Okay. What does that mean for people who don't know what?
He basically took a break from having a parliament.
Okay.
He said, "We're not going to bother
We're not going to do this anymore.
with parliament for the next 5 weeks." And I think really to get into military, we probably need to go back to the GCHQ case in the 80s.
Okay. And what's
briefly.
let's talk through the GCHQ case. Let's talk through the Miller case.
So GCHQ essentially established the fact that the court was able to judicially review decisions taken under the prerogative powers.
Okay.
So judicial review is a difficult thing to explain exactly what it is. But
Yeah.
we would probably use Lord Diplock's
Lord Diplock's
From
tripartite, you know,
tripartite test, which is
administrative law, man. That is a very good question.
so
Okay.
the
essentially,
reviews the
yeah.
things like the rationality of the decision making, whether this decision followed the correct processes you
Yeah.
need to make the decision.
procedural
Okay.
and
And
rational.
up until GCHQ, it was believed that prerogative powers couldn't be reviewed by the courts. It was just one
So
of these
say the
things.
Prime Minister decides he wants to go to law, there's to war, sorry, there's absolutely nothing anyone can do about it before
Yeah.
that. And now
Well, GCHQ doesn't say that suddenly all prerogative powers are
Court can't
Arbitrary.
overturn the prerogative power,
Okay.
yeah,
but the court can judicially review.
certain elements. And essentially, since GCHQ initially, the judges in GCHQ imagined it being very narrow, I think.
Mm.
They imagined that it would be sort of limited amount of decisions that would actually be able to, the limited amount of the prerogative powers that would be able to be reviewed.
Hmm.
But I think what we've seen, and we'll talk about Miller in a minute, is that since the 80s, there's been a sort of gradual increase in what the
Yeah.
courts decide they are able to judicially review, and that is so we've seen this sort of
Sort of
shrinking of how
came to
powerful the
fruition
prerogative
in
powers
Miller
are.
as well at its peak.
Yeah.
Where the courts found that Boris Johnson's prorogation of Parliament was unlawful.
Right.
So this was.
And so would
a
he have got in
landmark.
trouble for that? Well, did he get in trouble for that, or did they just overturn
Well, they
it?
just had to overturn it. They
Right.
say
Well, yeah,
that this decision, the first question in Miller 2, the court has to answer is this prorogation of Parliament that Umberto described, is it actually something that the court is able to review?
And so is Miller 2 the thing in relation to Boris Johnson?
Yes.
Okay, great.
So they say, well, can we actually review this case under this sort of GCHQ reviewing of the
Yeah,
prerogative
sure.
powers? And then they decide that they can. So then they do judicially review it. And they decide that this has essentially been done to frustrate the will of Parliament. So this decision comes at the tail end of the Lady Hale presidency of the Supreme Court. She's seen as quite a activist.
Yeah,
she's
definitely.
she's seen as, to use the sort of American terminology, she'd be seen as quite a liberal
Yeah,
justice of
definitely.
the Supreme Court.
Okay.
She's now been replaced by Lord Reed, who
But not for long.
But
Lord
who's
Reed
retiring.
He's going to be retiring, I believe, this
but
year. And I think
he is a much more restrained and small c conservative
Yeah.
judge, and so it's arguable that Miller 2 was sort of the peak of this judicial
Okay.
power, and now you wouldn't, had Miller 2 happen today under the Reed court, it's possible that they'd have shown more restraint, I think.
I think it's very interesting, especially it depends on how much you think, for example, in particular members of the judiciary, like the president of the Supreme Court, for example, how much they influence the rest of the decisions. For example, Lord Reed was obviously on the court, I believe,
Yeah.
in Miller
I
2.
think one of the things you could see
And
from this
it was a unanimous decision.
the change in
But
in Miller
yeah.
1, there's a dissent by some of the more, again, small c conservative
Right.
members of the Supreme Court. But by the time Miller
Miller
2
2
comes
comes along.
around, it's a unanimous decision. So the argument is, how much did the more liberal members of the court, like
Yeah.
Lord Kerr, Lady Hale, influence these more
Yeah.
conservative judges like Lord
Right.
Reed to come
Yeah.
round to their way of thinking?
Mhm.
And now that someone more conservative like Lord Reed is the president, whether that would change now.
Yeah, it's definitely an interesting question.
It's cool to see how the cases that your guys are studying are like extremely relevant to what's actually going on in your
Yeah.
lives. It's not like you're just reading stuff from 100, 200 years ago. It's like very much the course is like keeping up with the times. And I think that's a really good thing.
It's really fascinating to look at some of these big constitutional cases, and one of the best parts of being at Oxford is that obviously you've got some of the top academics in the world that are writing articles on these cases. They've written books on these cases. They have really strong views on them, and you can just go and watch a lecture that's being given by the guy who's written the book. Like, for example, here I've got a book from this is Private Law: The Discharge of Contractual Obligations by
Okay.
Jordan English, and really, really fascinating book, which was a great read. And if I have any question about what's in this book, I have got the author's email address, and
Great.
I sat in his lecture and asked him questions 6 months ago. So it's like it really is one of those sort of moments where if you're interested in this type of academia and this type of analysis of the law, coming to a place like Oxford or even a place like Cambridge, UCL, LSE, coming to these top law universities, Edinburgh as well, of course.
As a Scottish person.
Yes.
Hey, Cardiff University's not too bad as well. I've got to show support for the Welsh as well.
I think
Um,
on that note, I have got Timothy Endicott
yes,
here, who me and Umberto have attended
Yeah.
the lectures of.
Right.
a very good
He is
lecture
a
on
he
Minna
is a
1, Minna 2.
very well respected constitutional scholar.
lawyer.
He was actually the doctoral supervisor for one of the US Supreme Court
Oh, wow,
justices.
okay.
So yeah,
He's a very
Yeah.
So not only are
well-respected
you
and
guys
clever
getting
man.
able to study the laws that are like really affecting your lives right now, but also you're studying them online alongside the people who are like doing the groundbreaking
like at the
research
forefront
and
of,
the forefront
the
of it.
academia.
That's
It's
awesome.
it's really a massive benefit. And it makes it worth it. It makes it worth coming to a place.
Yeah, for sure.
Speaking of sort of legendary professors, we'll move on to Professor Ernst and
Wolfgang
Roman law.
So one of the peculiarities of Oxford and Cambridge that you'll find probably not to be common
Right,
in
okay.
other universities is the
Something
fact that
unique, yeah.
Roman law is actually a compulsory module that you have to take
Okay.
in Oxford. And even I think different to Cambridge. I don't actually know if it's compulsory in
It's
Cambridge.
less of a. I think they study it less in depth.
Yeah.
I think they study civil law.
So essentially, with Roman law, the biggest question that people ask is always why. Like, why
So
are
you're
we
just studying the
looking?
law of ancient Rome.
We're studying
Yes.
the private law of ancient Romans. So you will pick up the Institutes of Justinian, you'll pick up the Institutes of Gaius,
Okay.
Which
books
were
that were
textbooks for
written in
Roman
like
law students
Wow,
in
amazing.
2,000 years ago.
yeah, in the year 161 AD, the Institutes of Gaius were written. So it's like just some ridiculous stuff. You'll be looking at the history of Roman law as well, like how the Republic turned to the Empire, turned the Principate, the Dominate, all that stuff.
Right.
Like really, like it's essentially it basically turns your degree into a bit of a history degree for a chunk of time in many ways. And the biggest question is always why. Like,
Yeah.
why are we going to these like 2 hour long lectures where Wolfgang Ernst is telling us about a cow called Betty and whether or not if it gets stolen, whether or not you can vindicate it from the person who stole it from you. And the reason for that is that Roman law obviously had a huge revival when the Institutes of Justinian, the Digest, was found in, I believe it was actually either Bologna or Verona. And essentially, this was around the 1100s. And
Okay.
they found this big book, right? And this is obviously this is after in a historical period. Now, I'm not a history student, but this is from what I remember studying Roman law, in particular the Second Revival of Roman law. You've got this sort of war-torn Europe that's just finished going through a lot of massive conflicts.
Right.
All these countries are struggling to rebuild, and they need a structure and a legal system to do that. And so as a result, when people find this big book of law
It's
from
a
the
really big book
Romans,
as well.
Right.
it's a massive
It's
book.
like
We're talking like 4 books that are quite big. And they basically picked this up. And the digest at the time when it was written by Justinian in about 560 AD was failure. It
Right.
failed to achieve its goal, which was to sort of revive the sort of golden age
I
of
think he
Roman
might have
law.
died of plague or something when he was
Right.
trying to
Yeah,
implement it.
so essentially the digest at the time failed. It was not really very successful in doing what it said that it wanted to do, but it was perfect for. It basically became a manual on how to make a legal system. And when these scholars found it in Verona, they took the book to Bologna as well. That's actually part of the reason the University of Bologna, which is the oldest university in Europe, I believe. I think there might be a university. It's the oldest, I think, still running university in
Right.
the world.
Got it.
There are some older universities, I think, in Africa that predate the University of Bologna, but I don't believe they're still running. I might be mistaken about that, though. But essentially, the reason that actually universities, the first university in Europe, the oldest university happened, was to study the Roman law.
Wow.
And they took this book and they applied it to their countries. So all these countries, basically France, Germany, all these Germanic sort of countries would send their legal scholars to Bologna, to those universities, and study the Roman law and then bring it back. And you basically end up seeing so much Roman law influence in places like France, like Germany, the BGB, the French Code Civil.
Right.
Anywhere that has a sort of civil law system, which is
Yeah.
half of the world.
Right.
Yeah.
There's
Was
places like
massively influenced.
all the mainland Europe, elements of Scots law, elements of law in certain states in America, like Louisiana,
Mm.
are all based on this sort of civil code that this
That all
Byzantine
comes
emperor
from
wrote.
the Roman law,
Yeah.
and at the
And
time.
and when Justinian is writing his code, what he's basically doing is collecting the works of classical jurists who sort
Yeah.
of lived in the 1st and 2nd century
Right.
in ancient Rome,
And
and
he's
sort of
compiling it all into this big,
compiling it.
like,
And what he uses to write his institutes is the Institutes of Gaius,
Mhm.
who is a classical Roman jurist, and he was
essentially a professor, we
yeah,
believe. We don't know much about Gaius.
the only thing we know is that he wrote some books.
He
His
wrote basically
institutes were
textbooks.
not discovered until much, much later than the Institutes of
Okay.
Gaius.
Right. Right.
So the Institutes of Justinian, sorry. So the
Yeah.
Institutes of Gaius,
They were discovered in about 1850, I
yeah,
think. I
it's
actually
like
looked at this quite recently because the Institutes of Gaius, they do exist actually. There's a copy that dates from about, I think, the 600 that actually still exists in a museum, I believe, in Verona.
Oh, cool.
But it's been preserved a bit poorly,
Yeah.
so
Sure.
you can't actually read it anymore.
that's
They're
actually one of the things when we study Roman law. You'll get to the institute, you'll be reading the Institutes of Gaius, and he says, the things that make this are, and then it goes next 6 lines illegible, and then it jumps.
So it's I mean it's super cool. And it's immensely important if you're interested in private law, which
Okay.
is a huge part of the law. The majority of the law that
The
governs
course
our
we
day-to-day
actually
life is
study,
private.
the name of the course is A Roman Introduction to Private Law.
Okay.
That is the purpose of it, is to, there's so many of these concepts that are relevant in
Yeah.
contract and tort.
Yeah. Things
that,
like, for example, good faith. Um, if you like squatters' rights come a lot from Roman law as well. The idea of usucapio, being able to acquire possession, acquire ownership, sorry, by possession.
Hmm.
Usufruct. So you might have heard of someone having an usufruct or an interest, a life interest in land. It actually still happens in many civil law jurisdictions, including in Italy right now. My family actually has an usufruct in an apartment, which is crazy because I was learning about it in Roman law
Wow.
from
Awesome.
2,000 years ago. I mean, it's very niche, but San Marino, little country in Italy, independent country, but
Yeah.
one of the smallest countries in the world. It's basically just a mountain. But San Marino actually still cite the digest
I believe
as
it's
good
the
law.
only one that remains that's based now.
It's yeah,
that's
it's
Roman
so,
law.
but to the point that you can actually put like when you reference a legal argument in San Marino, you can cite the digest of
Wow.
Justinian, and it will be actual binding law.
You do
So
also come across the things that the Romans weren't as good at with their law, things like criminal law. They're
yeah,
for instance, their solution to a lot of things is to throw people off the Tarpeian Rock. Is one of the things you come across. That's if somebody commits a crime, that's generally
yeah, the
the
Roman,
very ancient Roman solution. And then they sort of move on to this system where everything is based on fines. There's not
yeah,
this idea of public justice. So we read this story about this man.
the
So
Roman slapper.
yes,
This was
so this essentially
I don't know, it
the
was like
Romans did not
Lucius or something.
inflation adjust their laws. So
Ah.
essentially, there was this law said, and it dated. It was hundreds of years old by this point. It said, I'm going to talk about this in modern currency to make
Right.
this easier.
Okay. Okay.
It essentially said if you slapped somebody in the face, you had to pay them 20p.
Right.
So there was this man who got his slave, and he went and got a bag of 20p's,
You
and
just
then
go,
he would go around. He'd slap people in the face, and he'd have the slave follow behind him and hand out 20p to
That's
everybody he slapped.
hilarious.
So I think there's elements of that where
yeah.
they have these really advanced ideas on private law, and then they have their criminal law system, which is just almost non-existent in the way we
Yeah.
imagine criminal law today.
I mean, there's a reason that we look at the Roman law as an introduction to private law.
Yeah.
The Roman public law. I mean, I haven't studied it because it's not on the course, but it seems like the general understanding is that it was far less developed. It's the
Right.
private law that's really influenced modern day private law and has influenced concepts, even to this day in the UK's contract law. Because an interesting question might be, well, if it influenced us so much. Why doesn't the UK have civil law system as well?
Yeah.
And the reason for that is because the
Well,
UK,
in Scotland we do.
well, in Scotland
In
you do.
Scotland we have a combination of English, of a
That's true.
common
I should
and
have been. I
civil
should have
law.
been more precise. I should have said, why do England and Wales not have a civil law system? Why do we have the common law system? And the reason for that historically is that we were not one of these sort of war-torn countries that
Yeah.
were looking for a manual to just be able to adopt and implement. We had the crown, we had the church, and we were already a bit more developed and established. So we'd already had our system in place. So
Yeah.
when people came up to us, when these legal scholars came up to us and they were like, "Oh, look at this great thing we found. Look at this, big system of law that we are going to take, and where basically it's given us a manual on how to build our legal
Societies, yeah,
system
yeah,
and our
yeah.
society." And we just sort of looked at it and said, "Well, we don't really need it.
Yeah,
We've
yeah,
got
yeah.
our
This
own
is sort of
system,
a-
and our system works."
Yeah, it's like a thing. It's really the answer to a lot of reason why the English law is the way it is. That they've never been anything like the French Revolution
Right.
or the equivalent of in Germany after the Second World War. The closest thing we probably have to that is the Glorious Revolution.
Yeah.
Yeah. William of Orange and stuff
The
like
sort
that.
of Parliament being supreme to the king, and that was the sort of end of the period after the Civil War. But we've never had a sort of
Never
comparable
had a
thing
big event.
where the government is being completely rebuilt from
Yeah,
nothing.
sure.
The way that the reason a lot of countries in Europe have adopted certain systems is because there has been a point where there was a crunch moment where they had to adopt something. Whereas in England, there's never been this
We've never quite
moment where we
reached
had to
critical point.
rip everything up and start again. So I
Okay.
think that is actually
I suppose
why
that's
a lot of these things
kind of
are the way
in
they are.
chimes with the whole civil law, isn't it? When it develops over time, or no, it's the other one.
The common law.
Common law, yeah, the
develops
whole
over
common
time.
law
Yeah,
thing
yeah.
where you're kind of developing through time
Yeah.
based on what's happened in the past, and because there's never been like a point where it's split, you've just got this continuity all the way through. Whereas I guess in other systems there has been that split, and so it encourages you to sort of start again afresh. Yeah. So you guys are covering so much stuff because some of the things you're saying has reminded me of the classics episode I did a little while back. You're kind of studying some of the foundational texts of Western civilization effectively in your Roman law. And then also studying stuff that's going to affect our lives right here, right now, today. So that's really, really.
We did want to talk about something that actually does affect
Oh
our
yes,
lives day to day,
yes,
which
yes,
is
let's hear it.
leases.
Quite interesting, actually. Leases and
Interestingly.
tenancies. So
Now, there is a difference between leases, licenses, all these different words that you might see in your tenancy agreements.
Okay. When you go to
So-
university.
Well,
You go to
for
university.
instance, when you're going into accommodation at university, you might see a different word.
this
Now,
might be something you want to pay attention to
yeah,
if you're going to be
the,
signing any
now
contracts.
the
because
definition of leases really comes from Street in Mountford.
Yeah.
Now, Street in Mountford basically says it doesn't matter what you call this thing. You can write license lease on it. It doesn't really make a difference. They say a lease has these characteristics, which are exclusive possession, a term that is knowable at the beginning of the lease.
Yeah, yeah.
So you can't say this is uh forever.
Yeah, yeah.
Or
It has to be
things
like
like that.
99 years. Or
Yeah, so
whatever.
that has to have like a fixed amount.
And there has to be it's not rent, but some sort of consideration for there to be a contract.
Yeah.
Which is a
Payments
requirement.
usually at the end of a set term.
Usually usually it'll just be rent.
Yeah, but that could be something else.
But it could be something else. So something that Umberto was sort of running by us earlier before we came on was about the idea of scouts in
which
Oxford.
just
Which for people who don't go to Oxford we have sort of cleaners, minders who come and pick up after us in our accommodation. I think Oxford accommodation is quite often a lot more like hotel rooms than your standard student flat is. It's a rooms along a corridor quite often where the scout will come in and make your bed, empty your bins, that sort of thing.
I think it varies from college to college.
Yeah, they don't make our beds here.
I was going to
They
say, I
empty
don't
our
think my
bins.
scouts ever made. I hope they've never made my bed. I'd be so embarrassed.
Well, and so Umberto was sort of talking about how this might relate to this idea. So if you were like leases and licenses.
So it's really interesting because in Street and Mountford, a very important part of the case is the fact that these people who were inhabiting these houses were not being provided with any service. So you were living in there, and then that was it. The person that the landlord, if you will, the to use in precise language, the landlord, wasn't
just to sort of clarify. We should probably clarify why you might want a lease or a license. Like what the
Yeah,
difference
yeah,
is.
yeah. I mean, we'll get to that in a second, I think, when we talk about why it's important, the distinction between the two. But it's like the they weren't receiving any benefits.
Right.
So they were literally just living there. They
Yeah.
weren't, say, for example, having,
Water or electricity or
Yeah,
whatever, yeah.
it was well,
Their
they,
meals cooked for them and
yeah,
stuff.
they
Yeah.
weren't
After
having
them,
like
essentially.
things like that. Whilst so that was a key difference, or it was a key characteristic of a lease rather than a license. The importance between the two is obviously that if you have a lease, you're a tenant. If you're a
Okay.
tenant, you're protected under certain property law legislation. Things, for example, like you can be protected from being wrongfully evicted and stuff like that. It's much harder to kick out someone who's a tenant rather than someone who just has a license to
Yes.
occupy.
Right.
So the interesting part is that obviously, well, how does this tie into the scout? Well, the scout is providing a service, cleaning your room,
Yeah.
they're, making your bed if you're lucky. And so in that sense, it means that the college that's offering you the accommodation can actually very well say that you are not a tenant, you are just someone who has a license to
Yeah.
occupy.
Yeah.
I
Yeah.
The
think while we
difference
were
being that you can be kicked out
thinking about
Yeah.
this as well,
quite easily.
in Oxford, we get kicked out every 8 weeks. We
Yeah.
have to move back.
Yeah.
So that's another.
Unless you
When
have
we were
a
talking about
particular contractual agreement.
These
Yeah.
idea in Street and Mountford of what makes a lease, then you need exclusive possession. And if the college can kick you out every 8 weeks, you don't have exclusive possession because the college are putting
Yeah.
someone
Yeah.
else in your room
Yeah.
for these while you're away for the vac. So I think there's a number of reasons why we don't actually have the
Yeah, and it's
protections
important
of
to
leases
look as
here.
well, if you're, even if you're going to another university, looking at the agreement and not just looking at the words of the agreement, but also looking at what the effect of the agreement, because that's what the courts in particular in Street and Mountford are being very careful to say, is that they're being careful to say that it's not what's written. You can call a lease a license, you can call
Yeah.
it a
Yeah. Yeah.
tenancy, you can say whatever it is. They're looking at the effect of the
Yeah.
agreement. And the effect of the agreement, if the effect of the agreement is to grant you exclusive possession for a periodic time in exchange for consideration, which is usually economic,
Yeah.
and you're, typically receiving sort of like you're not receiving rather any services
Yeah.
or additional benefits. Well, then it doesn't matter if they call it a license, that's
It's
a
a
lease,
lease.
and you're
Yeah.
a tenant.
Yeah.
And that means that if they come knocking on your door and saying, get out, you say, well, no, you have to comply with these specific regulations that are contained in these acts. If you have a license to occupy, you're not protected under those acts. So it's a really fun way of, again, just realizing how law is much more than just criminal law, it's civil law, and the majority of people, hopefully, will be interacting with the civil law more than the
Yeah.
criminal
Yeah.
law in their
Fingers
lives.
crossed. Yeah.
So it's important, and it just goes to show things like tenancy. I mean, Roman law, this idea of exclusive possession, you have a right against the world.
Yeah.
It's an idea that comes from Roman law. You have a right in rem, right in personam, right in property versus right in people. So it's really interesting to see all the links and how
And
it's
yeah,
come
you
to
can see
fruition
how
today.
this ancient thing that we discovered hundreds and hundreds of years ago and was written hundreds of years before that is still literally affecting the way that you might live your life at university
day.
or whatever.
Definitely.
Yeah, awesome. Right. I think we've talked enough about the cases and stuff now. There's kind of two things that I want you to speak about briefly before we finish. First off is you brought some work with you, you've just done your collections. Let's hear what was that like? What's it going to look like being a law student here in terms of not just what you're going to be doing in tutorials and what discussions, things, what you're going to be exploring, but also how does that, what you have to do with that information. So I've got a lovely illustrated little chart there.
Oh yeah, we've got Little
There's-
Timmy's registration adventure.
I
of
don't
the
think
land.
anybody would watch this if we go through
How
land
to rent-
registration in
okay,
great
yeah.
so
detail.
you basically made
There
like
are, there are ups and downs to the degree. I'd say reading 112 sections of the Land Registration Act would probably fall into the downs
you
category.
show it to the camera as well so you can see.
This is Little Timmy's land registration adventure, which is a bit of a more fun way of condensing what was not a very fun thing to read.
There's only so fun you can make the
Yeah,
Land
yeah.
Registration Act.
I think, do you want to maybe, because you've got a reading list there.
Yeah, let's
Yeah,
do
Do you
I
want
that
to
as
maybe
well,
start
yeah.
with the reading list and we'll look at what some of
So
the work
I've got
looks like,
perfect.
and then we'll look
my
at collections.
admin law reading list. I like to highlight things after I've read them.
Okay.
I like to print it out and then highlight things after I've read them. It makes it easier for me to, you know,
And so were you
track.
expected to read and know about all of these different
Yeah,
laws?
this is my week one reading on this
Oh my
page.
goodness.
So this is week one of admin law, the sort of introductory stuff. Then this page and these pages are That was week 2.
Yeah.
So it's a fair chunk of stuff, but
Yeah.
I guess we've
Fair
done we've
chunk
been doing it
is
every
a way-
week for
yeah.
however long. I
Yeah.
guess you sort of
You get used to
you
it.
get into it, and
You get
usually
smart
there's
about it as well.
and usually there's things that you have to read. Like, I mean, it's not always a perfect science, but usually you can guess
Yeah.
what's important and what's not.
Yeah.
There's things that you can pick up from other sources. For instance,
Yeah, law reports.
law, and also like things like reviews by the Law Commission.
Right.
Quite often they're hundreds of
Summarised and
pages.
stuff.
You don't have to read hundreds of pages of it. You want 2 points about their
Yeah.
recommendations, things like that. So there's things that you're
You can be
um,
tactical.
definitely reading, and then there's things that I hate reading, like anything by Albert Dicey. I don't know how you feel about Dicey.
Or A.V. Dicey.
Yeah, I just
My absolute king. I
he is
remember
he
him,
is
his rule of law.
this guy who wrote a textbook on constitutional law in the Victorian
Incredible.
period,
Right.
and he just makes stuff up. He's a shameless liar.
Everyone at that time made things up. That's all they
But
were
he
doing.
just will say these things that were like that are just and he makes these things that you probably would find too philosophical in your PPE
Yeah.
degree. He says things like what is it? In other countries, rights come from the law. In England, law comes from the rights. And things like this. And he's just
Yeah.
and apparently he was considered one of the top guys.
He
My
was.
tutor said recently that she'd been on a sort of retreat when she was doing a PhD, and the academic running it said if Dicey was a scholar now, he'd be laughed out of the faculty.
yeah, right.
Essentially, he is essentially doing PR for the Constitution. This is a bit of time, but he's a particularly annoying man to read. There's when you do this, you begin to recognize academics.
Right, yeah.
That you're like,
Some
not
that you
him again.
prefer, some that you don't.
Everyone has academics they like to read,
Yeah.
and judges they like to read. For instance, one of my hates for judges is Lord Denning.
Right. Lord Denning is a
Lord-
fantastic judge.
Lord,
okay?
Lord Denning. No, Lord
This-
Denning, he's got a great story. He was one of the first sort of working class men to go to Oxford in the sort of period of the First World War, and he initially I think wants to become a mathematician, and then he just decides on a whim to be a judge, which ironically is much how he decides everything else he ever does. But
dear.
essentially you get when you're reading a law textbook, it'll say the law was this up until the 50s. In the 50s, Lord Denning made up something.
Equitable common
Yeah.
mistake.
So hold on, we've got this system of common law. It's supposed to be based off past judgments, and you can just get random judges rocking out.
Right.
the thing,
I mean,
like-
this is an important distinction as well, and this is probably, again, an entire hour could probably be spent discussing this. There's a very interesting split in the UK between the common law and equity.
okay.
Denning was a big fan of equity. So essentially, I mean, like in very, very brief, they're two separate courts
Yeah, we used
that
to
were
have a
unified.
court that what we used to have up until the 1800s was a court that did law and a court that did fairness.
Okay.
Yeah.
Which is
In broad strokes,
yeah.
that is essentially what it was. The historical, obviously, it goes into a lot more detail on exactly why we had this split, but essentially, it was one court was the common law courts of the, and on one court was the chancery,
Right.
which was governed by the Lord Chancellor. And so you would essentially, if you went to the common law and your claim failed in the common law, if it failed under the king, you could then decide, oh, I'm going to go to the Lord Chancellor, I'm going to go to the Chancellor, I'm going to go to the Court of Equity, and I'm going
Yeah.
to get my fairness and my justice. And so you often find, the role that equity plays in the common law is very highly contested. The general consensus and orthodox idea seems to be that equity just accompanies the common law. So it will never go beyond the common law. It'll never do something the common law doesn't do, but it will just fill the gaps the common law sometimes
Got it.
misses. And Denning was a huge fan of using equity for this purpose. So he would make things like, for example, the doctrine of common mistake. He would say that if the doctrine of common mistake in a particular case failed in common law, he'd say, well, actually, there's precedent and there's historical basis to actually ground a separate doctrine of common mistake in equity.
We should footnote
that
this,
in
but
this
this is
case
just
doesn't fail.
This is a lawyer way of saying that he made things up.
Yeah.
It's a lawyer way of saying that he really, really stretched the bounds, but he did it in a very smart way. And like, I mean, there's a reason that people only really started overturning all of Lord Denning's stuff after he died.
Right.
Because it was like
He was too good.
no one really wanted
I think
to
one
mess
of,
with
one
the
of the
man.
best stories about him is he was a court of appeal judge,
Okay.
and he's and on the court of appeal there's only two other judges, so he
Right.
just has to convince one judge, and he's like the top guy at the court of
Yeah.
appeal, so he can always get another judge to agree with his madness.
Yeah.
And then he gets promoted to the House of Lords, and suddenly everybody just ignores him. Because it's like the top court,
Yeah,
and
yeah.
they're basically just like, well, this is nonsense. And
I
there's
mean,
more judges, and so what he does is he says, "Well, I'm going to go back to the Court of Appeal." So
Goes back
he gets
down.
he gets
Demotes
demotes himself
himself.
to the Court of Appeal, and then he's just back
Because
to
he can get away with nothing.
because he can get away with it.
Lord Denning, if you ever do a law degree and you to read a judgment by Lord Denning, you're probably going to read the most exciting judgment of your life, and know that this is going to be a fantastic judgment, because when you come to write an essay about it, you can poke holes in
And
the
you also
judgment.
you also know that it definitely got overturned in 2003.
Probably, yeah.
And on the essay writing, just to bring it to like collections and assessment and stuff. What are you when you're writing a law essay? What are you trying to do? Are you evaluating laws? Are you describing laws? What's going
I
on?
think you're always. I don't know how much this is true at other unis, because obviously I've only done a law degree
Of
here.
course, yeah.
But I think it's more. There's never. You're never just writing what the law is. It's the whole point of we don't do a law degree here. Technically, we do a jurisprudence degree, which is all about. I mean, essentially, what we do throughout this degree is develop our own personal legal philosophy
Okay.
and apply that across lots of different areas. And that's really what it's all about, especially the essay-based things. Because administrative law is always essays, what I'm doing just now, and there's always a sort of descriptive and then a more normative element.
Yeah.
So,
Normative being like you're prescribing some way things
yeah.
should be.
So really, the question will always be, every question in an essay comes down to what is the law and what should the law be,
Right.
and then what is the law? Obviously, you need to know, but you're not getting any points for knowing what the law is. It's just required knowledge. Where you get the high marks is the hearing the views of scholars,
Got
coming
it.
to a conclusion, and that's really one of the main things we are developing. I don't know if we'll have time to discuss jurisprudence
Probably
in more,
not
but
in
I
more
think
detail.
when you're
but
coming here, it is people imagine that it's just this module of jurisprudence that we do, but it really like
It informs the whole
our
degree.
personal
Yeah.
philosophies.
I mean,
come into everything.
so different, I think, to at least from the discussions I've had with people who go to other unis, where other unis will typically tend to focus on problem questions and just applying the law. Whilst at Oxford, it very much is, you're not just asked what the law is. It's like Edwin said, you're asked what the law should be.
Yeah.
And, that can be a bit overwhelming sometimes,
Yeah.
because you've got these people who, have been discussing this stuff for years and years and years, these debates that are, in some cases centuries long. And you're expected to pick up this material
Just
and
make a
in a
judgment.
week
Yeah.
read it all, understand it all, and come to your own conclusion
Yeah.
about it.
And then
so
quite
it's-
often your tutor is the leading
Yeah.
in that area.
So it's I mean, it really is a pressure cooker system, and it's fantastic in the sense that it develops your views, and it forces you to actually be able to interact with, for example, judges analytically. But it's something that a lot of people might struggle with, and it's also, in all honesty, not reflective probably of what you will be doing after your degree.
It's a very academic.
It's a very
based
academic thing.
It's
So
not,
if
it's
you're
not,
looking
you're
for
not
a
going to
more
learn how to be a lawyer.
vocational, if you're looking for a more vocational course, then maybe this isn't the course for you, because when you go and you're a barrister, and when you're going or you're a solicitor, you're not going to be
You're not going to
asked
say, well,
what
actually,
the law
I
should
think.
be.
Yeah.
You're going to be asked, well, what is the law?
Yeah.
So it's helpful in the way that it helps you inform and structure arguments, because obviously if you're writing an essay on a certain set of debates, when you come to say maybe represent that debate in court, both sides, you can play it around a bit more. But when it comes, especially for like, if you're looking to be a solicitor, a lot of the essays you'll find you'll probably do maybe hate and then never touch again in the real world, in the profession. But it's fun, and it's a degree for people who are interested in law and are interested in why the law is, what the law is. People who are interested in jurisprudence.
I would say if you've watched this and you think this was really boring, then just don't do a law degree.
Yeah.
Just,
If anything is boring, they're probably
you
left
need
already.
to, you need to become
exactly.
a, you,
But
you
if
would
you've
need to
made it
become a
to
lawyer.
this, if you've made it to this point and you're thinking like, oh wow, I've actually been quite engaged in maybe not all the things that we've been talking about, but some of the things that we've been talking about. If you made it to here, then do consider doing a law degree, and if you can, consider doing it at the University of Oxford, because it will stimulate you, and it will force you to produce reams and reams and reams of notes for what is essentially just like a week of work, which then end up just getting turned into little Timmy's registration, land registration adventure. So it's like there's fun to it as well.
Yeah.
Do we want to talk
What's
about
your
collections?
yeah?
or-
Well, that's not really the fun element.
That's
What's
not-
like,
no, that's not
what's
fun.
what you think is the most fun element of like
yeah.
your
Let's hear that.
degree?
What's the best part of your degree?
Best part of my degree is, in my opinion, talking about the law with my course mates.
Okay.
And I'm very lucky because
So
you
people
know,
are witnessing the best part of your degree, right?
yeah, they're witnessing the best part. The conversation, the 3 hour discussion we had on the way back from Malta was the best part of my degree. What I love is reading a case, thinking, I do not understand what on earth
Yeah,
the
yeah.
judge is saying here, explaining the reason I don't understand it to, say, for example, a friend, and then sitting down and working through it together. If we're looking at a problem question, we're looking at, oh, could it be this? Could it be that? We're sat around, maybe we're drawing some things down. It feels like we're solving a puzzle.
Yeah.
And when you organize your thoughts and you lay them down, you are genuinely able to condense information from, a
I
huge
think it's an
volume
advantage of the
into
small college
small
system
amount.
here as well. That sort of being able to talk.
Yeah.
I think that I would say to people who are coming here, you want to be friends with your cohort,
Yeah,
your
try your
college.
best to.
Because you're going to, well, we've come across some law cohorts who are very competitive with each other and don't get
Think
on. They're
corporate,
always
yeah,
trying to
yeah,
one
yeah.
up each other. Whereas I would
That's
say
just
both
not-
of our cohorts at mine at Teddy and Umberto's at UNIV, we're quite keen to work collaboratively, figure out things together. When we don't understand something, we'll sort of run it by each
Yeah.
other, ask each other questions, and I think that's a good way of doing it. I think you're never going
Best part.
to learn things as
It's like
well.
it's a team exercise at the
Yeah.
end of the day, because there's only so much that one brain can do, and it helps to bounce ideas off each other. Otherwise, you're just gonna go crazy.
And I think if you don't want to do that, then the tutorial system isn't really for you.
Yeah,
If you're
yeah,
not
true.
wanting to come to
Agree.
uni and have
And
these discussions and
have the
debates with each
discussions.
other and share ideas, then
If
the
you're
tutorial
scared of being
systems are
wrong and saying
collaborative.
something that's not right, then you need to let go of that fear the moment you step into whatever doors of whatever university you're stepping into. Be open to being wrong, because if you're wrong, that's great. 'Cause
Yeah.
then you can be right.
Yeah.
So it's like, it's the first step to being right is to be wrong sometimes. So unless you're just right at everything,
I
which
think you
probably
remember
probably
the
aren't.
things
Yeah.
Yeah,
you
definitely.
messed
Yeah,
up
yeah. It
with
sticks in your
to-
mind more. Yeah.
Yeah.
Definitely.
You don't.
Then you remember.
I remember the
this-
cases much better that I had no idea what was going on than I do
the
the
time you
sort of
spend trying
mundane
to
ones.
understand a case.
Yeah.
The more time, like I can't remember a lot of the simple cases, but I'll always remember some of the cases that we've discussed today, because they're cases that make you think, and they're cases that you discuss with people,
Yeah, yeah, yeah.
and they're cases that are fun.
Yeah.
To talk about, obviously, in the abstract, no reflection on the facts of the case. Those were not very fun.
Yeah.
The principles that they bring forward are fun.
And then finally, I just wanted to ask you about the kind of law society and like what the broader Oxford law community looks like.
Yeah, I think Umberto will be best placed to talk
Yeah.
about this as the current treasurer of the
Yeah.
society.
So it's so the Oxford Law Society is a society, so it's run entirely by students. It's
Yeah.
not run at all by the faculty, and it's essentially a group of people. We are actually, funnily enough, an unincorporated association. So the Oxford Law Society doesn't have a legal identity. It's
Okay.
just a collective sum of people who come together, the members of the society, the committee of the society. I'm currently the treasurer for this term, so positions are held termly, which means that when this term ends in sort of the second week of March, I will be
Free.
putting down the mantle, and I'll be passing it on to my successor. And then I can either choose to stay in the committee of the society or just go back to being a member. The society sort of aims to put on events for law students and non-law students that are interested in law. It's very important to remember that, in most solicitors' firms, 60% of the people working there did non-law degrees,
It
and
could be
then
a bit of a
converted.
sore. I think it could be a bit of a sore point with some of us who do law
Yep.
degrees
Yeah.
when we're reading, having to read Roman, spend 8 weeks doing Roman law, and then somebody like Tim who's doing a
Yeah,
PE
yeah,
degree
yeah.
could just waltz in
Yeah.
at the end and do a
It's-
conversion.
It stings the pride sometimes, but
Yeah.
it's a fact that needs to be recognized, and it's also very exciting because it means that if you're interested in, for example, pursuing law as a profession, and you didn't like any of the things that we were talking about today, don't be discouraged. You can still be a lawyer. You just
Yeah.
don't need to study law, which seems counterintuitive,
Yeah.
but you'll
I think it's a
learn
distinction
lot.
that people in who probably at the end of school
Yeah.
aren't aware of drawing.
Yeah.
We're doing a completely different thing from we're studying law, but it's completely different from
We're
being a
studying the
lawyer.
subject. We're not studying the profession.
Yeah.
So it's very much like if you are interested in being a lawyer, whether that be solicitor or barrister, I'd say if you want to be a barrister, a law degree is probably a good thing because with a barrister, you're probably going to be more excited in the law anyway. It's going to be your job. But if you're looking to be a solicitor, I mean, you're basically going to be learning on the job. If you just do a law degree conversion, you're not going to be doing any of this fancy jurisprudential
Yeah.
stuff. You're just going to be learning the law, applying it, which is what you're going to be doing in your job, and maybe you like that more than the what should it be, what is it, what
Yeah,
can it
yeah,
be.
yeah.
It's different
Way of thinking, yeah.
tastes for different people.
Anyway, so you said about events you put on.
Yeah,
Like
definitely.
any kind of examples to give
Yeah,
people an idea
well, I
what
mean,
you're
we've
talking
got
about?
bunch of good events
Great.
happening this term, which is great. I've had the privilege of being able to help put a lot of those events on. In particular, we run sort of all things. We run social events, so there's going to be like a social welfare event where we buy some like ice cream for our members, and people can
Lovely.
come and just sort of
How much is the membership
enjoy.
out of interest?
The membership is £50, but it's
Okay.
I believe it's a life membership.
Yeah,
So you pay £50 in your first year, and that's that.
I mean,
You're
in
just
terms
a
of,
member.
I'm not sure how much you're going to use.
So essentially, it's open to all members. We'll run welfare events. We'll run sort of free ice cream. We do like at the minute, obviously it's mods term. So at the end of this term in Hillary, all of the first year lawyers are going to be sitting their law exams.
Yeah.
So we do welfare events for them. We pack them little goodie bags. We do
Oh,
mods
lovely.
panels. So like we get
See,
people who in the past.
I don't think I got a goodie bag
Well,
last year.
that's why we're doing it better. We didn't get goodie bags, but we're making goodie bags for the members this year. We do things like mods panels, so we get people who in the past have won prizes or have gotten distinctions. People who've performed really well in their exams. They come on, sit on a panel, and the first
Yeah.
years, or anyone can ask them questions about how to do well. We also run, a lot of networking events like drinks, presentations, mainly like commercial solicitors firms,
Yeah.
but also some criminal sets like barristers' chambers as well. We're actually running a speed mooting competition this term, which is great.
What does that look like?
So essentially, a speed moot is like a fake trial.
Right.
And a moot is a fake trial, and a speed moot is a moot but accelerated.
Yeah.
So essentially, 48 hours before the day of presenting to a judge, you're going to be given a problem. You'll be expected to write an answer to that problem, and then you'll have 5 minutes to convince the judge that you're right on that
Wow.
problem. And there'll be sort of an appellant and a respondent, or defendant claimant. Two sides, they'll be arguing against each other. With this speed moot, there'll be no right of reply, but that's because we want it to be super quick. And thankfully, we're hoping to get sponsored by some big chambers to be able to run this, big commercial chambers, because we're looking to be it's looking to be a private law speed moot, so things like trusts, contract, law of tort, maybe. It's more aimed towards our second and third years.
Yeah, for sure.
And I'm, very thankful that I'm actually able to be in charge of organizing that.
Right.
So it's one of those things that, if you're looking to be a committee member, it comes with its challenges. It definitely adds to the workload.
Yeah,
And it comes
for
with a fair bit of stress, but it's also very rewarding. And, we run dinners all the time. We had a committee welfare, like cocktail making event a couple of weeks ago. So it's a fun way to get involved more in a society that provides a lot to both law students and non-law students looking to study law or looking to go into a legal profession. And if you do end up coming to Oxford, please buy membership. Join the society. You'll have a great time.
Great. Awesome. Well, that's all the questions I have for you guys. I don't know if you think I've missed anything.
I mean, we can go on the
I
rest of the
think
day.
we could go
We're gonna
on.
have to
I
draw
think
the line
at
at
some
some
point
point.
we'll probably call it there.
Cool. Great. Well, thank you both very much for giving us this almost hour and a half of your time to talk about law. The longest episode yet, but that's all good. And hopefully people who are still here found it super interesting to learn all about what you're actually learning about when you do jurisprudence at Oxford. So yeah, thank you very much for coming on, and goodbye.